The Delhi High Court, which has allowed Tata Sons to pay over $1 billion to its now estranged telecom partner DoCoMo. The Reserve Bank of India objected to this settlement, citing forex laws which do not allow fixed return to foreign investors. But the High Court has rejected the objections raised by the central bank. So, Mr. Khan, if I could get your first comments, and then I'll come to you, Mr. Chakrabarti. Mr. Khan, does this not leave the Reserve Bank in a bit of an embarrassing position, sir? The High Court saying very clearly that, the RBI had no jurisdiction to intervene in this matter.
I had a very quick and cursory look at the judgment. It's quite elaborate and lengthy judgment. I have not gone through in detail. But my sense is that the judgment has not examined the substantive part question. And I don't agree, somehow I'm not able to appreciate how court can say that the RBI has no locus standi in this case. Because there is a public policy, there is a public law. If some contract is not in conformity with the public policy or public law, my understanding is that the contract will be void ab initio. So whatever manner you want to give an award, whether you call it damage, you call whatever name, it will be contrary to that. That is a very technical point. But I would go one step forward. That there is a need, scope to look at the whole issue holistically and create a framework to take care of these problems. This problem holds legacy cases where both investor and investee has gone into some contract and things have moved. Many investors in future also will like to have some assured return because the dynamics of the investment has changed. So we need to look at the policy in a different manner. But as policy stands now, in my mind, the judgment has not appreciated that. But there is a strong case for relook at the policy. That is my first point.
But you're saying that there is a strong case to relook at the policy. But Mr. Khan, if I could just read out to you the operative parts of the judgment, sir, and it says there is no such statutory requirement that where the enforcement of an arbitral award might result in remitting money to a non-Indian entity outside India or to an account of an entity outside India, RBI has to necessarily be heard on the validity of the award. The mere fact that a statutory body's power and jurisdiction might be discussed in an adjudication order or an award will not confer locus standi on such body or entity to intervene in these proceedings.
I am not a legal person, but let me ask you a hypothetical counter question. If the arbitration decision is given which goes against the Constitution of India, will you affirm that arbitral decision? If a decision goes which is against the law of the land, will you uphold that arbitration decision?
Let me get Mr. Sibal to answer that question, sir. We've got with us Mr. Kapil Sibal also, sir. We've got the former RBI Deputy Governor, Mr. H.R. Khan, there, saying that he doesn't quite appreciate the order that's come in from the High Court, and he believes the RBI does have the locus standi. If you could explain to us and respond to the comments that have come in also from the former RBI Deputy Governor who's with us, Mr. Sibal.
No, I don't want to respond to any comments. All that I can say is that supposing, I give a hypothetical, supposing there's an arbitration in respect of a foreign investor investing into an Indian company, and that matter goes to arbitration, and an arbitrator, set of arbitrators renders an award. Then the matter comes to India, and that award is upheld by the High Court and then upheld by the Supreme Court. And the Supreme Court directs monies to be paid to the foreign investor. Will the RBI say, no, this is against the Constitution of India? As you know that the law laid down by the Supreme Court is binding on every institution, including the RBI. Yes, because the RBI is not concerned with the award. The RBI, in this particular case, intervened in the matter. We raised an objection that an arbitration between two parties is not something that can be interfered with by a third party, which has nothing to do with the dispute. There's a shareholders agreement. There are certain clauses in the shareholders agreement. Parties went to arbitration, and the arbitrators has rendered an award in damages. And once an award is rendered in damages, then international convention has it that governments have to pay. That's the law. It's not against the Constitution. It's not against any law in this country. What he's talking about is agreements, shareholders' agreements, in which you have a assured rate of return, no matter what the market value of the shares are at that particular point in time. Such agreements are bad in law, because you cannot give an assured rate of return if the market, if the shares in the market are lower, if the value that is to be given is higher than the market value. It cannot be done, because RBI guidelines are quite clear on that. But if it's an arbitrable dispute and there's an award and it's upheld by courts, then the RBI cannot oppose it. That's the law.
Yeah, well, two things, sir. I think the Deputy Governor merely is saying that how can you say that Reserve Bank has no locus standi? If two parties...
No, I'm not saying that.
No. That was the question which the Deputy Governor is raising, the former Deputy Governor, Mr. Khan, is raising. The judgment seems to say that RBI has no locus standi in this because it's an arbitral award. And he is saying, how can you say that? If two people went to an arbitrator outside India and the arbitrator gave a decision which contradicts the Indian constitution, then will the Indian court say, no, you have no locus standi, the arbitrator has ruled?
No.
I mean, that was the point he was making. That is the point he was making.
No, but that's a wrong question, because whether the award is violative of any law has not to be decided by the RBI. It has to be decided by a court of law.
Yeah,
right?
That's a
RBI
fair
is not
point.
an adjudicating authority.
No, that's a fair
that's
point.
Number one. Yeah. Number one. Then in every international arbitration, RBI should be a necessary party. That cannot be.
No,
because if the Deputy Governor is right,
if it's a tax arbitration,
every proceeding.
No, if it's a tax arbitration, I don't think RBI will want to be there.
It may be any arbitration. No. It may be any arbitration. Why tax arbitration? Once there is compensation in terms of repatriation of money from India to an outside entity, then the foreign exchange is impacted. So the RBI must be a party in all those proceedings.
Well,
now this is absurd. I mean, on the face of it is absurd.
Yeah.
Two entities are in dispute. There's an award. Award is filed in a court of law in India. The court considers whether it is illegal or void. And if the court upholds it, all parties are bound by it.
Yes, certain. No, that point is taken. Obviously, the RBI is subservient to what the court says, but it will perhaps take it to a higher court. That's pretty much possible.
That may be so. That's fine. They're entitled to do that.
No, also, the former Deputy Governor is raising the point that in this case, the party concerned is in violation of existing RBI law, taking a price, a kind of an assured return on its share, on its investment, but only calling it damages.
No, this is completely wrong. This is completely wrong. First of all, who is the RBI to say that it is not damages? This is an award through an international arbitration. They say it is in the form of damages. DoCoMo invested $2.5 billion in this country. And they said at a given point in time, if there is a trigger after a notice, then Tatas will have to buy the shares. And if the price has fallen, then DoCoMo will take a hit of $1.25 billion. In this transaction, DoCoMo has taken a hit. They brought in $2.5 billion. They're going out with $1.25 billion. So there is no even loss of foreign exchange. But be that as it may, that's on merits. The question is at this point in time, Tata was not obligated to pay in Indian rupees. Under the contract, there was an obligation to find foreign buyers to buy the shares.
Okay.
So the arbitrators have said this was a mandatory obligation. And since they did not discharge that obligation, they have to pay damages. And the High Court has said, yes, this is an award in damages. And under international law, once there's an award in damages, no regulatory authority can intervene.
Okay.
And in any event, Reserve Bank of India has no right to intervene in an arbitration proceedings in India.
Shireen?
Mr. Sibal, you know, the former RBI Deputy Governor also now saying that post this judgment, perhaps there is a need for the Reserve Bank to look at putting a policy in place to try and address the precedent that's been set by this judgment. So if you can take us through the implications and the precedent that this judgment sets.
No, on the contrary, there are no precedents. You see, remember, the policy of the Reserve Bank of India today is perfectly clear. If there is an assured rate of return to a foreign investor, and if the market price of the shares falls down, and still the foreign investor is entitled to a higher rate of return, it is contrary to the guidelines. It will not happen. So transactions with an assured rate of return fall foul of the RBI guidelines. Perfectly good. This is nothing to do with that issue. There is no assured rate of return here. Here, DoCoMo has lost $1.25 billion. That's number one. Number two, in this transaction, there was no assured rate of return because the transaction said that after a certain point in time, once a trigger notice is given, you have to buy back the shares, and if the value is less, I am willing to take a hit of $1.25 billion. That is, I am willing to take only 50% of what I invested. So in fact, there is no assured rate of return. Government of India has got more foreign exchange than it lost out. Because what came in is 2.5 billion,
Mr. Sibal,
what went out is 1.25 billion.
No, Mr. Sibal, I'll tell you what the Reserve Bank's argument has been all along. The argument is that debt comes with an assured return, maybe 1%, 2%, 0.5%. But equity, you can lose all, or you can get 200%, 300%, 500%. You can lose all. Whereas in this particular transaction, equity says, I will not lose all, at best I will lose half. To that extent, it's an assured protection. And that is the position that the Reserve Bank took.
It's not an assured protection at all. What is assured is that if I get in some money, I don't want to lose all of it. I'm prepared to lose half of it. But in any event, the award is in damages.
Fair enough.
There is no repatriation based on the agreement. The award is in damages. That Tata ought to have accessed foreign investors to be able to buy these shares, and had that been done, there was no need for the Reserve Bank of India to come in.
Yes. No,
so there was a provision in the agreement by which they had to access a foreign entity to buy these shares. That was the first option. If they could not do that, then of course the second alternative was this. But they having failed not to get a foreign entity, then the award was given in damages.
I take your point, sir, but my sense is that the Reserve Bank is going to argue and say that this is just renaming the assured return as damages. But in any case, it's the Reserve Bank's preserve to take the case forward or not take it forward. Separately, what Shireen was asking you, sir, is whether the time has come to rewrite the law itself, and that is what Mr. Khan was saying, that maybe the Reserve Bank and the government need to sit together and rewrite rules to say that international investors these days want some kind of flexibility, some of them want some kind of protection, and therefore very clearly the law should allow that the equity investments should be allowed to put a stop loss, that the laws should be reinterpreted to allow that.
You must understand, in this particular transaction, and the judge has mentioned it in his judgment, the Reserve Bank of India, in fact, did not object to DoCoMo getting this money.
Yeah.
They even recommended that this is fairly good because they brought in 2.5 billion and they'll be taking out only 1.25. It is the finance ministry which objected. Right.
So,
and in fact, it was at the direction of the finance ministry that the RBI then took up this objection.
So I'll just complete this story for you.
Even the RBI was not objecting to
I'll take your point. I'll take your point. In fact, I'll complete the rest of the story for you. Thereafter, what the Reserve Bank did on February 3rd, 2015, in its monetary policy statement is, it said that we are going to bring new set of rules whereby we may even allow assured return, maybe 2 or 3 percentage points lower than the risk-free rate of return. But 25 days later, in the union budget, the government said the Reserve Bank shall no longer have the power to make rules on equity inflows into India. That power shall be done by the government. So anyway, the Reserve Bank lost the power and could not, bring those rules.
There's another issue here. You see, the fundamental law of India is to honor international obligations and international conventions. And the international conventions and obligations require that if there's an international award, and that's part of our Arbitration Act, that once there's an international award under Section 48 of the Arbitration Act, it has to be executed as a decree in India.
Okay. Well, Mr.
Now,
Khan,
the fundamental law of India has to be... fundamental law of India has to be... This is the fundamental law.
Okay.
The RBI guidelines cannot override the Arbitration Act.
Fair point, sir.
And honoring international conventions. Okay. So the fundamental law of India is to execute international arbitration awards.
Fair point, sir. Mr.
And
Khan...
therefore, even under the Contract Act, such an award cannot be rendered void.
Okay. Fair point, sir. Last word for you, Mr. Khan, on this issue.
No, as I mentioned, and the court will obviously have the final say, whether it is High Court or Supreme Court, they will have final say. And if there is a ruling, my understanding is that whether the government and RBI has to obey the ruling of the court. Having said that, but let me repeat and reiterate that point, we are missing the wider picture. The wider picture is that we had some cases where some investments have happened in a particular manner. And we are also in future will get private equity and other type of investors whose horizon will be, investment horizon will be different. The dynamics of business is changing. So we need to put in place a framework which takes care of these legacy cases or also future cases where there is some protection. Okay. Maybe it could be linked to some market benchmark and give some discount to that. Some protection because the dynamics of investments have changed. So we have to keep the big picture in mind. And if you don't do that, you will have several such cases where arbitration, court order, each contrary to other, then we have to fight whether the law will stand or arbitration will stand. So we are all getting into a very messy thing. And it is not only one case, there are several cases. And if you say whether it is damage or is otherwise, you would tell different names and change the semantics. But the basic point, I think we need to address this issue. And we look at the policy, and there is no need of changing the act.
Okay.
What is needed is change in regulation.
Okay, let me get Mr. Sibal to have the final say on that. Mr. Sibal, you've just heard what the former RBI DG has had to say, that given the dynamic market situation that we're faced with, investors may want some protection. You may not need to necessarily amend the Act. You need to do something about the regulations to ensure some degree of protection. Your final say, sir.
I think that the way the world is moving and the way India is in fact persuading foreign investors to come here and invest, they also want that their investments are safe. Sometimes what happens is that a foreign investor comes in, he invests, and suddenly finds that some court ruling, has made his enterprise of no value. Now, something like this, when it happens, foreign investors then don't want to invest in India. And our court systems and our court rulings, for example, if you cancel all the coal blocks, you cancel all the telecom licenses, why would an investor come and invest in India? And you have in fact the example of Vodafone selling out, or rather, doing a merger with an entity. You have Telenor going out of India. You have Etisalat going out of India. You have all the foreign operators have gone out of India. Now, if our regulations and our laws are such that they don't encourage foreign investment, why would anybody want to invest in India? I think the RBI regulations should be far more elastic and flexible to encourage foreign investment. And of course, if there are some agreements which are unconscionable, certainly they should not be acted upon. But I agree. Well, I think that the dynamics of economic activity is such that we need our system to be far more flexible and conducive to foreign investment.
Well, I think both you and the former RBI Deputy Governor in agreement on that issue, maybe not necessarily on this specific matter, but Kapil Sibal, the counsel for DoCoMo, and H.R. Khan, former RBI Deputy Governor, appreciate you joining us here on CNBC TV 18.